Planning Board of Florida is now in session. Please be seated.
We now proceed to the third case on our docket today, Tisdale versus the State of Florida. Counsel.
My name is Jeffrey Garland. I am here on behalf of Eriese Alphonso Tisdale. He maintains that his sentence of death should be reduced to life. Critical to this case is the issue of retroactivity of Chapter 2016-1032. This case went to a jury before Hearst v. Florida was decided. The sentencing was postponed. The legislature passed 2016-13. Sentencing took place after that point. An abundance of case law from this court has held that these procedural statutes are retroactive. In fact, the death penalty statute itself says all proceedings must proceed under the death penalty procedure.
But are you saying, here's the problem I have, this jury didn't know that if they were either less than 10 or unanimous, that there would not be a death penalty. So it seems to me that it is really no different than any of the other cases post-Ring, where we held that in a non-unanimous verdict there should be a new sentencing. I don't really get why yours, which was under a statute which was then declared unconstitutional, would apply to mandate, it's procedural, that it be reduced to life. I mean, I just don't see that.
That takes me to point 3, which we'll address first, which is
well, isn't the only issue here, again, and maybe I'm missing something, either he gets a new sentencing phase or he gets reduced to life?
Correct.
Okay.
Correct. And point 3 deals with the new sentencing phase under the controlling precedent of this court. I don't think that's an issue because it was a non-unanimous jury. The judge found the existence of 40 mitigating circumstances, and obviously it was a misinstructed jury under Hearst v. Florida and under this court.
So we're only here because of this fact that the sentencing took place when the legislature had passed the statute, the 10-2 statute, which was subsequently declared unconstitutional?
There are different aspects of that argument, but that is correct.
Okay, but it was declared unconstitutional. It requires a unanimous verdict, but there was never a situation where we said all those cases that were decided where the jury came back should get reduced to life, other than, when Justice Perry, dissented on what we determined should happen.
Well, this court in Perry v. State did determine that it is retroactive and it's applicable to cases that were then pending in the courts. And I would submit that the Tisdale case was then pending in the courts.
It was, but it was not the 10-2, but it was for, not that the 10-2 was appropriate.
Well, in Perry v. State, it went up on 2016-13, and that was the 10-2. That was in place at that particular time. After that, the legislature amended. Obviously, the question here that Mr. Tisdale is concerned about is that this court has determined that if there's a unanimous verdict, no matter what the defects in the instructions, that those death sentences are valid. And I submit that if the finding of the jury is sufficient to uphold the death penalty when it's unanimous, then the same jury finding of 9-3, which is not sufficient to uphold a death penalty under the current statute, should be considered by this court as a finding of fact, a
Well,
verdict.
then we would have to, then we would have to receive from every single case where we have sent it back for resentencing.
I'm concerned that the finding of this court that a case in this unusual, perhaps unique posture could cause exactly that sort of inconsistency in the rulings of this
What
court.
was the jury told about what it should find or could find?
They were given the standard instruction.
So there was no instruction given to the jury about, in order to impose a death sentence, you have to, at least 10 of you would have to agree, or any instruction to that effect?
No, they were told that they had, that a recommendation had to be at least 7 of them. And it was the standard jury instruction. The point of the fact here is that there was the recommendation. It says the recommendation. The current statute says recommendation, and 2016-13 says recommendation. We have a recommendation of 9 jurors. 3 of them recommended life. That's not sufficient. That is no less significant than the 12-0 verdicts that this court is upholding death penalties on. I suggest.
So your argument really is that any case where the jury made less than a unanimous decision should be reduced to life?
No, ma'am, I'm not going that far.
Well,
That's not the argument.
Is it post-Ring, all those cases?
Well, let's start with Ring. Ring v. Arizona, because this is the starting point. And when we look, for years this court has struggled, and the Supreme Court has struggled with the similarities between Arizona's death penalty sentencing procedures and Florida's death penalty sentencing procedures. Billington v. Missouri taught that if the jury makes, in a contested evidentiary hearing, a finding of fact and returns a verdict, that that is a double jeopardy bar to a subsequent sentence of death. That's what Billington v. Missouri says. We subsequently know that in Arizona v. Rumsey, Billington v. Missouri was applied. And so we know that under the Arizona sentencing procedures that it's an adversary proceeding. If the jury recommends life, that can't be reversed. It's a double jeopardy bar.
Then your argument is that the 9-3 was a factual finding by the jury?
That is correct. That is a verdict.
And so since it was not unanimous, it then becomes a life sentence?
Under the law in effect at the time, it had to be 10-2. And
But that statute was invalidated in Perry because we said it had to be unanimous. And so, again, I'm trying to find out what distinguishes your case from any other case that was tried before the court and then the legislature required that the findings by the jury had to be unanimous.
because this case was sentenced after 2016-13 went into effect. That statute says it's retroactive to all cases. All precedent of this court says these amendments are retroactive. It's not a change in the death penalty. It's a mandatory procedure that must be followed. It had to be followed. If it has to be followed, then if it's not followed, this court is...
Well, then what you would have to, you would be saying then, to me, the jury had to be told it was 10-2. So what you're really asking is it goes back and they'd only have to find 10-2 rather than unanimous?
The jury couldn't have been told 10-2 because it didn't exist at that time.
But because the jury wasn't told, they didn't have all the facts upon which to make their all-important findings regarding the ultimate sentence to be imposed.
That is true, but in cases that are 12-0, that doesn't seem to matter. And in cases of the United States...
It's saying in those cases, it's harmless error beyond a reasonable doubt, because they found all of those requirements that the aggravators outweigh the mitigators unanimously. So that is why those cases said, it didn't say it didn't matter, it said it was harmless beyond a reasonable doubt. It's not a structural error.
Well, that is a matter of some debate, whether the findings could be made when there's no instruction on that, which gets back to the question that you just made, is should they have been told that it was 10-2?
It just seems to me, if you're arguing this is unique, you need to stay with that. But if you're arguing that the court has been inconsistent, I think I'd have some of my colleagues would agree with some of the inconsistencies. So we did the best we could post-Ring, post-Hearst, and we're here now on very few cases that still have to be decided before we now know that all the verdicts have to be unanimous. And every single one of them, if it's not unanimous, we've reversed for new trials. So new penalty phase. So the only issue for you is that it was in this unique window that you ought to get the advantage of the 10-2 fine requirement, and that's your argument, right?
In the briefs, I referred to it as unique. I can't sit here before the court and say there is no other case like this, but there are probably not many. It could be the only one. Yes.
But what I'm struggling with here, and again, I have a little different perspective on this than the majority, but I'm struggling with the fact that the majority's declared that statute, right?
Yes, sir.
Well, that's the law, and I'm struggling with how that declaration that law was unconstitutional doesn't come into play in this direct appeal. Because you're relying on this law that was declared unconstitutional by the court. So help me understand how you can do that.
Well, Perry v. State addressed that, and so did Evans v. State, which was a follow-on. And there was a discussion in the concurring and dissenting opinions about severability. And the concept of looking at a statute, trying to remove the parts that are unconstitutional, if the remaining part can stand, then if it accomplishes the primary purpose of the legislature, then it remains valid. And what was decided is that as far as the amended statute goes, eliminate the 10-2, make it unanimous. The remaining portion of the statute was valid.
But you're relying on the part that the court declared to be invalid, right? You're saying there wasn't at least a 10-2, that was an acquittal. And that whole thing your whole argument seems to me to be based on that provision of the statute that was declared invalid by this court, and that's not the law. I mean, because in the direct appeal, we apply the law as we understand it, and the fact that somebody maybe misunderstood it back then, that it was on the books, doesn't matter. If we've declared it invalid, then it's invalid, right?
Yes, sir, I agree with that as far as decisional law goes. But the change here is not decisional law that I'm contending. It's statutory law. And the court can't intrude so far into the requirements of the legislature. They passed a law that was in place at the time this sentencing took place that said...
When we declare a law constitutionally invalid, we typically declare it invalid from the start.
Okay. In this case...
I mean, insofar as pipeline cases are concerned, obviously with post-conviction is a whole different thing. But if it's a pipeline case and we've declared a law to be unconstitutional, then it's like it never existed. That part that we declare to be unconstitutional. Isn't that correct? Isn't that just kind of a basic part of the way appellate process works?
I think that is true generally, but when we take into account the rule of lenity, the Eighth Amendment, and due process, I think we reach a different result in this particular case because...
But you would then concede we've got to put aside that generally prevailing principle to go down the path you want us to go down.
Because this is a unique case.
Right, okay.
This case...
So I sort of see this as two very distinct legal issues. One is whether the sentence gets vacated, and then the second, and it's that you get to if the sentence is vacated, is what's the remedy? Is it a life sentence, or does the state get a chance, an opportunity to have another trial, right? Those are two separate legal issues, right?
That is
Okay.
correct.
And in this case, you're saying on the first issue, there's an extra reason to vacate the sentence. So even if this law had never been, the 10-2 law had never been put into effect, you would get you would have Hurst relief because it wasn't a unanimous jury verdict. So that the sentence would be vacated under this court's precedent, correct?
That is correct.
And under that reason, which is the only kind of case we've talked about, it's clear that double jeopardy, the U.S. Supreme Court has held, and we've applied, we've held that double jeopardy doesn't prohibit the state from getting a new trial, correct?
In most cases, true.
Okay. So here, what you're saying is that there's another reason to vacate the sentence because the law in effect that applied at the time of the sentencing hearing did not allow for the death penalty, and so we vacate, right?
That is correct.
Okay. And this is, so we agree, vacate the sentence. I think we all know that that's going to happen, either rationale. But when you get to the second issue, I don't understand why the analysis is any different under the U.S. Supreme Court case law and our case law. In other words, at the time of the jury trial and jury verdict and recommendation, the law would have supported a death sentence. And we have held that under those circumstances, if the sentence is vacated, double jeopardy does not bar the state from retrying. And so when you get past the decision that yes, we're vacating and there are two reasons to do it, you haven't shown me any reason why the general law relating to double jeopardy and sentencing in this context would not apply.
Well, I think that Bullington and Arizona v. Rumsey answer that question. They say that the jury finding, there's a factual finding here, there's a verdict of 9-3, and what we
And that
have,
would have supported a death sentence at the time of the verdict, correct?
That's correct. The
Okay, and
legislature
double jeopardy would not rebar. If the law changes, double jeopardy generally doesn't rebar.
Well, that's true, but the legislature chose to pass a law that was retroactive that gave more beneficial position and said that it had to be 10-2. They lowered the bar. And at that time, the Florida had a bifurcated system. The jury made a recommendation. The judge didn't impose sentence until after the statute went into effect. The statute was the binding law at that time. Perry v. State was decided by, I think, the 5th District, and it was stayed by this court, so it wasn't in effect. There was nothing to say that that legislative enactment was not valid and binding law of the state. Mr. Tisdale was entitled to that law at the time of his sentencing, and the state never tried
Which
to...
is a reason why he's getting relief. He gets his sentence vacated. It's a second reason. Hurst gets it vacated, but that law would get it vacated too, but...
Exactly. And
I still don't see why double jeopardy would...
But the secondary, because of the benefit of the legislative enactment, they can't seek the death penalty again, because that was the law in effect at the time. It is prohibited by double jeopardy. It's prohibited. There's another part of this brief that if somehow...
It wasn't the law in effect at the time of the trial and verdict.
Well, because of the bifurcated system, it's the law in effect at the time of the sentencing. The ultimate sentencer was the judge, and the judge was bound by the statutory law, which required 10-2. If for some reason the statute does not apply retroactively to this case, that's a special carve-out, and that's addressed as point 2 in the brief, that there's nothing in this statute that allows for a carve-out. It talks about all, and it talks, and it's retroactive. So any decision that would make this statute anything other than completely retroactive to all cases then pending is a carve-out. And I submit that under Eighth Amendment precedent, due process, the rule of lenity, that's not permitted. This is a unique case, I submit. It may be one or two others, but it's pretty limited scope. I submit to you that this case should have been decided on the statute at that time, and the statute prohibited imposition of the death penalty based upon the verdict, which was at an adversary hearing by a fully instructed jury. Even if it was a wrong instruction, the case law out of the U.S. Supreme Court is that the wrong rulings can still bind. There was a verdict of 9-3 in this case, and I submit to you that that is the law that should be applied in this case, and that, yes, the death penalty should be set aside because of Hurst v. Florida, but the state should not be permitted to seek death again because of the statutory change. the ruling should be because of the statutory change, regardless of double jeopardy. But when we look at double jeopardy, when we look at the requirements of due process, when we look at how this case was structured for sentencing after the statute went into effect, then I think that it compels the conclusion that in this unique and unusual case, the proper remedy is to vacate the death sentence with instructions to impose life.
And what was the case that you said from the U.S. Supreme Court that compels this result?
Well, there's a series of U.S. Supreme Court cases like U.S. v. Burks. They talk about.
I mean, you mentioned a different one, but is there a case where a verdict? I guess it would have to be. Well, there's jury sentences and some sentencing in some states, but a verdict would support a sentence at the time the verdict was entered, but the law changed, and the court said that double jeopardy would bar a new jury trial on the issue that mattered when it came to sentencing. Is there a case like that?
There's a variety of cases that talk about rulings that were done improperly. They shouldn't have been done either because the judge misunderstood the facts.
But none like this. I mean, this factual scenario is unique, not only because we haven't addressed a case like it, but I think you're conceding that it's unique and that the U.S. Supreme Court hasn't really addressed a case that's directly on point and says.
I couldn't find a case directly on point. But I have reserved some time, and thank you.
Good morning. I'm Assistant Attorney General Donna Perry. I would like to start with issue number 1. There are really 2 sub-issues in regard to issue number 1. The first is that 2016-13 did not apply to the defendant's case. Here we have not only the entire trial that was conducted prior to that amendment and prior to Hearst versus Florida, we have the sentencing as well in the portion where the jury was making their recommendation. That actually occurred on October 9th, 2015, 2 months prior to Hearst versus Florida, 3 months prior to.
I mean, wasn't the trial judge correct in determining 4 days before the sentencing hearing when Hearst versus Florida came out that he could not proceed to sentencing because our death penalty scheme, as the U.S. Supreme Court put it, had been declared unconstitutional, so there was no constitutional statute that would authorize the death penalty, and he had to wait to see what happened?
No, he was not correct in that.
Really?
He was correct in that at the time Hearst versus Florida invalidated what we currently had, but there were proceedings that were put in place in prior cases that were later upheld, such as doing specific interrogatories. Of course, we were beyond that point in this case because we had already had the jury recommendation and we'd already had the entire trial. But there were avenues by which he could have proceeded. And here, in fact, he took a break so that both parties could make whatever legal arguments they wanted to in regard to Hearst, which was a good decision to do in case there were arguments that would have applied here. The fact of the matter is that there weren't. And the reason it wouldn't have applied here is because the statutory amendment that came later ended up being invalidated by this court.
So you would agree that under our precedent, he gets a new sentencing?
I would not. That would be in regard to harmless error, which I will address shortly.
Well, okay, but based on all of our other cases, which say in a non-unanimous verdict, and in this one even, that it wasn't even, I mean, it's still on appeal, that the current statute requires unanimity, that this would be subject to a unanimous verdict.
I would agree that thus far this court has not found harmless error in any case that was not unanimous. If you'd like, I can address.
But even in this case, again, it's even in the situations whether something should be retroactively applied, we now have a statute that says it has to be unanimous. So
yes.
You're going to argue harmless error even in light of the, how many mitigating factors did the judge find?
There were 40, however, 32 of them were given no, little to no,
and
or
wasn't
little
there
weight.
a Spencer hearing where the judge heard evidence that the jury didn't hear that was beneficial? and no special verdict to explain what led to the 9-3. We don't know whether sufficient aggravators were found. We don't know any of that.
That's correct that there was no special verdict. However, we do know which 2 aggravators were found. The reason that we know is because both of them were inherent in the verdict. The judge in this case was particularly careful not to consider any aggravators that were not inherent in the actual verdict. The 2 aggravators that we had here were that the defendant killed a law enforcement officer, which was inherent in the conviction for count 1, first-degree murder of a law enforcement officer.
What aggravators was the jury instructed on?
The jury was not instructed on specific aggravators in the manner that you're indicating, as in a special verdict form.
No, but what aggravators were they told they could consider?
They were told that they could consider that the victim was a law enforcement officer, that there were a prior violent felony, which again is inherent in...
I understand that. What else?
The other 2 were merged into victim was a law enforcement officer.
There were no HAC, CCP?
There were not.
And they weren't instructed on that?
They were not.
So only 2?
That's correct.
And those were the 2 that were unanimously found as a result of the guilt phase verdict, correct?
That's correct. So in regard to 2016-13, the provision that the defense seeks to apply here is the exact provision that this court invalidated in Perry v. State. And as you indicated during the course of their argument, that is an unconstitutional provision that couldn't be applied not only to that case, but to any case in the past or in the future. The second part of their argument in regard to issue number 1 is that double jeopardy would bar resentencing. Clearly, that's not the case. In fact, this court just in March decided Victorino v. State, where the court rejected the argument that defendants who are not unanimously sentenced to death cannot be resentenced after Hearst because redoing the penalty phase would violate double jeopardy. In fact, this court stated, quote, "The Hearst decisions do not acquit Victorino of his 4 death sentences," and went on to say that double jeopardy does not bar a new penalty phase. The Victorino case was determined based on a U.S. Supreme Court case of Sataza. Now, the defense cited Bullington and Rumsey. However, right in Sataza, the U.S. Supreme Court distinguished both of those cases. The reason they distinguished those cases is because in Bullington, the jury found that the prosecution had not proven any aggravating circumstances, and thus the defendant was actually acquitted of the fact that which would have made him eligible for the death penalty. In Rumsey, the court actually found that no aggravating circumstances applied, and for the same reason, the U.S. Supreme Court said again, that defendant was acquitted of the fact that would have led to the death penalty. That's clearly not what we have here. That's not what we had in Sataza, and that's why Sataza was that which you based Victorino on.
I think we agree with your argument. I'm just going back to what makes this different on harmless error than all the other cases that we've reversed.
Okay, moving on from issue number 1 then, if we address harmless error, there has been a solid wall of precedent in the past approximately 15 months coming from other jurisdictions, including the U.S. Supreme Court, that has talked about the fact-finding that's required under the Sixth Amendment, and that talks about the fact that the weighing and the question of mercy are not fact-finding requirements of the Sixth Amendment, and thus does not have to be found by the jury.
Could you deal with our precedent and say how, under our precedent, this would be harmless error?
Under the current precedent of this court, there isn't a case that indicates that anything but a unanimous verdict would be harmless. However, our precedents all say that a harmless error analysis must be performed. And if a proper harmless error analysis is performed, one has to disregard the actual numerical count because...
I agree with you on that. We don't look at, but the mitigation, whether the jury heard it, and at least 3 of the jurors, wasn't even 11-1, must have found, if you said the aggravators were proven, that the mitigation was not, outweighed the aggravation.
Well,
we don't know because, again, there was no special verdict. So we are left with that the state, can't, I don't know how the state ends up proving in this case, without receding from every other case, that the courts decided that it's harmless error beyond a reasonable doubt.
I don't actually think you would have to recede from the other cases. I think what you would have to do is take a look at the cases that have come from all the jurisdictions, including the U.S. Supreme Court in the past 15 months, and indicate that upon re-examination of the harmless error standard, which is what this court has said the entire time needs to be applied, that harmlessness can be found even in the face of a non-unanimous verdict. And that's because, again, the actual numerical count would have to be disregarded. And the reason it would have to be disregarded was enunciated by this court when you initially decided Hearst 2. This court actually stated that, quote, juries not required to reach unanimity tend to take less time deliberating and cease deliberating when the required majority vote is achieved, rather than attempting to obtain consensus. That's exactly what we would argue, is that here, this jury was not told they had to be unanimous. They were told as long as you have a majority, you can apply the death penalty. So when they got to that point that they had a majority, they weren't going to keep pressing each
That's
other.
why we don't know what they would have done. I mean, that's where the state can't really get the benefit, just like the defense lawyer said they want, to be sentenced under a statute that was declared invalid. It seems that the opposite is this: we require juries to be instructed on what would have been the law at that time. And that's really, again, I agree with that. Maybe they will come back with a unanimous verdict if they know they have to be unanimous. But that would be speculating.
But it wouldn't be speculating. It would actually be speculation to try to determine why those three didn't come back. What we have to do under the harmless error analysis is to ignore that 9-3 and look at the evidence based on an objective measure of reasonableness, not based on the speculative nature of why those three jurors may have voted the way they did, because frankly, they may have voted the way they did because there was a majority and they just decided to stop deliberating at that point. The U.S. Supreme Court in Jenkins versus
Who
Hutton,
has to prove harmless beyond a reasonable doubt?
this court has determined that the state does.
Okay, so you're saying that what we would do is, even though there are other possibilities, which is three jurors found that the aggravation did not outweigh the mitigation, or that they voted that it was still not the appropriate penalty, you would ask us to speculate that the reason could have been the three jurors, not one juror, did it was because they didn't have to do it. I mean, that's speculation.
No, I would ask you not to speculate on why they didn't vote for death, and instead to do an objective determination based on the evidence in this case, and based on the fact that the only two aggravators that this jury considered, and the only thing that's required by the Sixth Amendment, is the existence of an aggravator. And that based on the two aggravators here, which were both found by this jury, that in fact the death penalty was appropriate. In Jenkins versus Hutton, approximately 1 year ago, the U.S. Supreme Court decided that Hutton had the existence of two aggravating circumstances determined during the guilt phase, and that, quote, each of those findings rendered Hutton eligible for the death penalty, end quote. Applying that reason that that jury determination during the guilt phase made him eligible for the death penalty, there isn't any Hearst or Ring error here. The only way there would be Hearst or Ring error is if we didn't have an aggravator that was in fact inherent in the verdict. Shortly after Jenkins versus Hutton, the 11th Circuit came out with Waldrop versus Commissioner of Alabama. In that case, the court determined that the jury had found the existence of a qualifying aggravator beyond a reasonable doubt when it returned its guilty verdict for murder during a robbery. Exactly like we have here. We have a guilty verdict for murder of a law enforcement officer, and that finding alone qualifies the defendant for the death penalty. After Waldrop, the state of Ohio Supreme Court had State versus Mason, which came out. In that court, the Ohio Supreme Court stated, quote, weighing is not a fact-finding process subject to the Sixth Amendment, end quote, and then went on to cite 13 different cases from 13 jurisdictions across this country, both federal and state alike, where the courts determined that the weighing process or the question of mercy was not what needed to be determined by the jury in order to satisfy the Sixth Amendment, that the only thing that needed to be determined was the existence of an aggravating factor. After that, we had the 10th Circuit that came out with Underwood versus Royal, And the 10th Circuit held that the court's decision in Hurst versus Florida was limited to aggravating circumstances and did not extend to mitigation or to weighing. So given that wall of precedent that's come out in just the past approximately year, 15, 16 months, the state would ask the court to re-examine the way that we pursue, the way that we apply the harmless error analysis. We're not asking that you retreat from it. We're not asking that you go back on any of the decisions that you've made thus far. We're just asking that you re-examine the way it's applied and apply it pursuant to the way that the U.S. Supreme Court and more than a dozen jurisdictions across the country have determined that it needs to be applied. And if we do that in this case...
Well, I understand your argument. You say that you're not asking us to recede from any precedent, but your argument, basically, as I understand it, is that Waldrop would say that Hurst versus State was incorrectly decided because it said that the Constitution required juror weighing.
Waldrop would indicate that the only thing needed would be the existence of the aggravator, right. Yes. And additionally, I would point out, Justice Lawson, your own dissent in the Alex Pagan case, where you indicated, in fact, that a proper harmless error analysis was not being done. So I would ask that you re-examine the way in which that is done. If there are no questions on issue number 3, I would like to address sufficiency of the evidence, since this is a direct appeal. Even though it wasn't raised in the defendant's brief, in case there's any question about whether this is sufficient. We have a dispatch recording where you actually hear the entire time frame that encompasses all 4 of the crimes that we have here. The dispatch tape starts with approximately 45 seconds of the sergeant giving the vehicle's make, model, tag number, and location. He actually has to repeat it a couple times, which is why it takes 45 seconds, because the dispatcher didn't understand what he was saying. There's only approximately 15 seconds of quiet before Sergeant Morales then says that the defendant is taking off on him. What we know happens during those 15 seconds is what was testified to by Casey Fednick. She testified that she saw the defendant go by very quickly, blow through a stop sign. She saw Sergeant Morales coming after him with his lights on. She saw Sergeant Morales stop very quickly. There were several seconds that were paused, and then all of a sudden he took off after the defendant again. That is when he would have said on the dispatch tape, at 1 minute, he's taking off on me going north on Naylor. After that, we have approximately a minute where he doesn't say anything on the dispatch tape. However, we know what happens during that time from the testimony of Albert Krasniak and the testimony of Jerry Pilarski, as well as the testimony of Deputy Bennett. Jerry Pilarski testified that during those approximately 1 minute, 45 or so seconds to a minute, he indicates that he saw the defendant stop very quickly on a gravel road. This caused, of course, Sergeant Morales to stop very quickly. Unfortunately, the defendant knew he was going to stop. Sergeant Morales didn't, so his reaction time took him a little longer, and he ends up sliding, swerving to the left, sliding in front of the defendant's vehicle, which gave him the opportunity, the defendant, to then jump out of the vehicle, run behind the sergeant's vehicle, go up to the open door, and shoot into the vehicle, which was seen by both Jerry Pilarski and Albert Krasniak. At that point, Albert Krasniak testifies that he then sees the defendant, after shooting Sergeant Morales multiple times, run back to his car with his arm pointed behind him, parallel to the ground. Now, Mr. Krasniak didn't see that Deputy Bennett had come upon the scene at that point because he indicated he was too busy running away at that point. But what he sees is the defendant with his arm pointed straight out, gun pointed at something down the road. Then we have the testimony of Deputy Bennett, who indicates that as he came down Naylor Road, he saw the defendant running to the open door of Sergeant Morales' vehicle and shooting into the open door, shooting Sergeant Morales multiple times. The defendant then starts to run back to his vehicle, points his weapon at Deputy Bennett, which causes him to stop very quickly, jump out of his vehicle, and then fire multiple times at the defendant, who Deputy Bennett describes as, at that point, trying to acquire him in his sights in order to shoot Deputy Bennett, which is the basis of the aggravated assault with a firearm charge. At that point, Deputy Bennett testifies that the defendant gets back into the red Toyota and takes off, which was also, of course, seen by the lay witnesses that were on scene. Deputy Sarvis and Deputy Stubley, luckily, were just approximately a block away, and as soon as the information was radioed over dispatch, and in fact, this is how we know about the timing of the shooting, because at that point, as soon as the defendant leaves, Deputy Bennett gets back on dispatch and says, "Shots fired." He testifies that that happened after the defendant took off, because of course he wouldn't have had the opportunity to radio that while he's engaging into the gunfire with the defendant. So he indicated that the actual shooting of Sergeant Morales happened approximately 30 seconds prior to that 2-minute mark. Why that's important is because the murder occurred between the 1-minute mark where Sergeant Morales says he's taking off on me and the 1-minute 30-second mark where Deputy Bennett came on the scene. That left only approximately 30 seconds, and that 30 seconds is documented by Casey Fedgnick's testimony about how Sergeant Morales stopped briefly, several seconds, never got out of the car. There was no altercation at that time. She, in fact, testified that there was no yelling even at that time. So there was nothing that would have occurred there that would have led to any conclusion about the defendant acting in any way a self-defense type of manner. At that point, Deputy Sarvis and Deputy Stubley had gotten behind the defendant and with lights and sirens were chasing the defendant who refused to pull over, which is, of course, the basis of count 4. They actually had to do a pit maneuver in order to get the defendant's vehicle to stop and ended up hitting his vehicle, causing him to crash into another person's vehicle. The DNA in this case matched by 1 in 15 quintillion the defendant's DNA to the DNA on the gun that was found in the defendant's vehicle immediately after the defendant was finally stopped. And in addition, the ballistics testimony matched all of the bullets on scene, all of the casings, to either Deputy Bennett's gun or to the defendant's gun. The reason that that is important is because Sergeant Morales never pulled his weapon. In fact, it was still in its holster when his body was removed from the vehicle. So there's no way that any type of indication where he could have been threatening the defendant in any way occurred. His weapon was still in its holster. All of the bullet casings on scene matched to the defendant or to Deputy Bennett, not to Sergeant Morales's weapon. Given all of this evidence, the evidence here, frankly, is overwhelming. It's not just sufficient, it's absolutely overwhelming. However, I will cite to 2 cases where sufficiency was found. These are also the 2 cases that I would cite for proportionality. And they are Bailey versus State. In that case, the defendant killed an officer after being stopped for a traffic violation because the defendant was on probation and didn't want to go back to jail. Several lay witnesses actually saw the shooting, and the defendant had then made an admission to a lay witness afterwards as soon as he had fled. Very similar to what we have here, where lay witnesses saw the shooting and the defendant made admissions once back at the police station. There were 2 aggravators found, prior violent felony and avoid arrest, very similar to the 2 aggravating factors that we have here. There, they actually had a statutory mitigating factor, which we do not have, and they also had 8 non-statutory mitigating factors that were given little weight. And even with that, this court found that the evidence was sufficient and that the death sentence was proportional. There's also the case of Burns versus State. There, an officer pulled the defendant and passenger over. Dispatch confirmed that he had asked for a check on the registration and the driver's license. The officer went back and ended up searching the vehicle and found cocaine. The defendant then struggled with the officer and was seen by several lay witnesses grabbing the officer's gun and shooting the officer. There was only 1 aggravator, and it was given great weight, and that was that the victim was a law enforcement officer, and there were 2 statutory mitigators. Again, we don't have that here, both age and no significant criminal history, and there were 3 non-statutory mitigating circumstances, and despite all that, this court found both sufficiency and proportionality. Given that, I would ask this court to find not only that the conviction should be affirmed, given that there was more than sufficient evidence, but also that the death penalty be affirmed, as it is proportional, and in this case, any error is harmless. If there are no further questions, I will relinquish the podium. Thank you very much for your time.
If it please the court, during the course of the penalty phase, the defense put on extensive mitigation in the form of expert witnesses, family members, friends, employers, which established an extensive basis for the jury to evaluate and find the existence of mitigating circumstances, which would substantially prove and support the 3 jurors who found in favor of life. I asked Justice Lawson about a case where there was error, and in Evans v. Michigan, which was Supreme Court 2013, it's in the supplemental authority. In that case, the state of Michigan judge in an arson case ordered a judgment of acquittal because of his misunderstanding of the law. Clearly, he was wrong. And the issue of double jeopardy was raised.
That wasn't, we're not talking about sentencing, we're talking about guilt.
What we are talking about, but what we have there,
There's
we
really no
have-
question that the judgment of acquittal would,
but I submit that what it amounted to was a verdict. And I would submit that on the sentencing aspects, when there's a verdict or the substantial equivalent of a verdict, then that is entitled to double jeopardy protection. That's what we learned in Bullington v. Missouri, Arizona v. Rumsey, and what we have, we would submit, is a 9-3 in this case. So that coming back to...
But in those cases, the jury made a determination that would preclude the application of the death penalty under the law under which the jury was instructed, or a finder of fact made such a determination. And this just seems different. I mean, we've talked about that, but those cases don't really get you to where they're distinguishable from where you are here, aren't they?
I can see where they could be distinguished to some extent, but on the general principle that they represent a verdict, and there are fact findings and there are verdicts that have to do with sentencing issues. And I submit that the verdict is subject to a different consideration. It's a 9-3. If that's considered a verdict, then the change in law captures that, converts it into a life sentence. That's what we submit. So that is a subject of Eighth Amendment concern, due process, as well as double jeopardy. These things are briefed.
would you agree that Waldrop says that weighing is not, under the Sixth Amendment, a jury function?
I didn't read it that way. I don't read that the weighing is inherent in the jury verdict in this sort of case, because they have to balance the aggravators against the mitigators. That's exactly what a jury does, so weighing is a Sixth Amendment issue. I mean, I would submit to you that's what a death sentence is all about, is the weighing process, guided by discretion and instructions and aggravating and mitigating circumstances and consideration of what the evidence is. I disagree with that. That's the scope of Waldrop. So, if there are no other questions, then on behalf of Mr. Tisdale, he would request the court to vacate the sentence of death, remand with instructions to impose a life sentence. Thank you.
We thank you both for your arguments. We now proceed to the fourth and final case on the docket for today.